somewhere right now, someone is sitting at their kitchen table at midnight.
Yeah, we've all been there.
Right. The house is completely quiet, except for, the hum of the refrigerator. And they've got their passport lying open right next to their laptop.
Oh, and just staring at that screen.
Exactly. The harsh blue glow of the screen is illuminating a U.S. visa application form. And they are quietly, genuinely panicking.
It is a terrifying moment for a lot of people.
It really is. Maybe that someone is you listening right now. We know exactly what you were afraid of in that moment. You're worried about saying the wrong word at the interview, right?
Or just having your voice shake.
Yeah, having a shaky voice, or about a stern officer looking at you through a thick pane of bulletproof glass and basically deciding your entire future in a frantic 3-minute window.
It feels like you're studying for a massive exam where you don't even know what the subject is.
Exactly. But what people almost never realize is that the interview itself is actually the smallest part of the whole journey. The decision is mostly made long before you ever reach that window, driven entirely by the choices you are making right now, tonight, at that very table.
That is so true. The foundation is built right there.
Right. So, welcome to Let's Talk U.S. Immigration. If you are planning a trip to America, you may be wondering why a simple visit needs permission at all, and, well, which kind of permission you actually need.
Which is a very fair question to ask.
Yeah. For many travelers from Europe, the answer is just a quick online approval. But for many others, it is a full visitor visa applied for at a U.S. embassy with an interview that people literally lose sleep over for weeks.
Oh, absolutely.
So today we walk you through that whole journey, warmly and in plain language, for anyone facing their very first trip into a U.S. embassy. We're going to cover why visits need permission, which visa fits which purpose, and how to complete the famously tricky application form without the mistakes that catch people out.
Plus, we need to talk about how the process has grown stricter lately.
Yes, definitely. And finally, how to walk into your interview calm and genuinely ready. Before we begin, though, everything you are about to hear is designed to inform and educate. Immigration law is incredibly complex, and every single case is different.
Right. You always need to check your specific situation.
Exactly. What you learn here should always be discussed with a qualified immigration attorney before you take any steps. We are the AI hosts for this series, and we're walking through legal research carried out on behalf of the team at the law offices of Chris M. Ingram.
It's going to be a really deep dive today.
It is. So I want to start by framing this whole ordeal because, the anxiety around visas usually comes from a fundamental misunderstanding of what a border actually is.
Oh, for sure. People get that totally backwards.
Right. We treat it like a customer service interaction. Like we have a plane ticket and therefore we have a right to enter. But from looking at the legal research provided by our team, that's completely wrong.
It is.
The foundational question we have to answer first is, well, why does visiting America need permission at all?
It fundamentally changes your posture when you understand the mechanics of sovereignty. Like every single country on earth decides who may cross its borders.
Yep.
When you arrive at a port of entry, whether that is John F. Kennedy Airport in New York or a land border in Texas, you are not exercising a right. You are making a legal request.
You're asking for a favor, essentially.
You are essentially knocking on the door of a sovereign nation and asking to come inside. And, well, the host country naturally wants to establish a few basic facts before they open that door. They want to know, who are you? Why are you coming? And quietly, but incredibly importantly, do you intend to leave again?
Right. And I think people take the questioning so personally. You stand there in line, you've been on a plane for 10 hours, you're tired, and suddenly you feel like a criminal suspect just because they ask where you're staying.
It feels very intense in the moment.
But it isn't a personal interrogation. It's a universal equation. My understanding is that every country asks these questions. The United States just shifts the timeline of when they ask them, right?
Exactly.
Like, they don't want to figure this out at the airport. They want to figure it out while you're still sitting in your living room.
Which makes sense. Imagine the logistical nightmare, not to mention just the human cost. If a family of 4 flew 12 hours from London to Los Angeles, only to be told at the arrivals hall that they couldn't enter.
Oh, because of like a paperwork issue or a background flag?
Yeah. They would have to be detained, kept in a holding area, and physically flown back across the Atlantic on the next available flight. It would be devastating.
Wow. Yeah, that would be a nightmare.
So to prevent that chaos, The U.S. relies on a system of advance permission. They push the vetting process outward, far beyond their physical borders.
That actually makes a lot of sense when you put it like that. So for short visits, this advance permission essentially takes one of two forms. The first is a quick online approval for certain travelers, and the second is the full visa, which is the one you apply for at a U.S. embassy.
Correct.
Let's start with that first path because, well, if you can take it, it's by far the easiest. In the research from our legal team, this system is referred to as ESTA. How does ESTA actually work in practice?
So ESTA is a streamlined, automated travel authorization system. It was designed specifically for citizens of countries that participate in what the U.S. calls the Visa Waiver Program.
Which is mostly Europe, right?
Think of most of Western Europe, yeah. If you are holding a passport from Germany, France, Italy, Spain, the Netherlands, or Ireland, for example, you are generally eligible to take this route.
Okay, I love this part of the legal research. It's like getting on the VIP guest list at an exclusive club.
That's a great way to look at it.
If you're on the list, you bypass the velvet rope entirely. You don't wait in the long line winding around the block, and you don't have to face the bouncer, which in our case is the consular officer at the embassy.
Right, you get to skip the tough interview.
Yeah. You just pay a small fee, fill out a form on your phone or laptop, and the system usually pings you back an approval within a day or two. You never set foot inside an embassy.
It is incredibly efficient. But, remaining with your club analogy, being on the VIP list means you are bound by very strict rules once you are inside the VIP room.
Oh, right. It's not a free-for-all.
No, ESTA is definitely not a blank check. It comes with firm, immovable limits. First, it is strictly for short trips of 90 days or less.
And that means exactly 90 days, right?
Exactly 90 days, not 3 months, because some months have 31 days. If you calculate it as 3 months and stay 92 days, you are in serious trouble.
Oh, okay. People probably mess that up all the time.
They do. And second, your purpose for being in the United States must be restricted solely to tourism or casual business.
But wait. Human nature dictates we take the path of least resistance. If ESTA is so fast and so cheap and requires no interview, why wouldn't someone just use her for everything?
Because the temptation is there, sure.
Right. Say I want to go study in California for 6 months, or I want to go work for a tech startup in Austin. Why not just click the ESTA buttons, fly in, and figure the rest out later?
Because misusing that system triggers devastating legal consequences. The 90-day limit is a hard legal line, as we mentioned.
Yeah.
You absolutely cannot use ESTA to engage in productive employment in the United States. You cannot use it to enroll in a long-term degree program.
Not even just a few classes.
No, long-term studying is out. And you certainly cannot use it to fly over with the secret intention of marrying an American citizen and adjusting your status to stay permanently.
Right, you can't sneak in to stay.
Exactly. And if you stay beyond that 90th day, even by a single afternoon, you have committed a visa overstay. The automated system cracks your exit, and overstaying on ESTA often results in you being permanently barred from ever using the ESTA system again for the rest of your life.
Permanently barred? Just for overstaying by an afternoon?
Yes. The system is incredibly unforgiving.
So the convenience comes with a zero-tolerance policy for abuse. But the research from attorney Chris Ingram points out that not everyone with a Western European passport automatically gets this VIP pass. Like, you can actually be knocked off the list before you even apply.
Yes, eligibility is a privilege, not a guarantee. If you have ever been refused a U.S. visa in the past, or if you previously overstayed a visit, ESTA's door is closed to you.
Even if it was years ago.
Even if it was years ago. Plus, if you have traveled to certain countries designated as state sponsors of terrorism or regions of concern by the U.S. government, you lose your eligibility.
Right, because of security concerns.
Exactly. And crucially, if you have a criminal history, which is a topic we are going to dive deeply into shortly, you are disqualified.
Okay, so if ESTA's door is locked to you for one of those reasons, or, if your plan is simply bigger than a 90-day holiday, you need a different path. You have to step out of the VIP line and go through the main entrance.
You have to face the bouncer.
Right. You're entering the world of full U.S. visas. And what's fascinating here is that the U.S. doesn't just hand out a generic visa. Our attorneys emphasize that you have to match the door to your specific reason for knocking.
It is a critical foundational concept. Picture the U.S. immigration system as a massive bureaucratic hallway lined with dozens of highly specific doors.
Okay, I'm picturing it.
If your true plan is to marry an American and settle down, you must apply for a fiancé or spouse visa.
Right.
If you intend to work for a U.S. company, you need an employment visa, which requires corporate sponsorship. If you want to enroll in a university, you need a student visa.
So each door has totally different locks and keys.
Exactly. Each of these doors represents a distinct legal avenue with its own massive set of rules, timelines, and evidentiary requirements.
So arriving as a casual visitor, when your actual intention is to marry or work or study, that's knocking on the wrong door.
Yes, and that is very dangerous.
From what the legal research shows, doing that isn't just a minor faux pas. It can cause catastrophic trouble. If you lie about your intentions at the border, what actually happens?
It is classified as material misrepresentation.
That sounds heavy.
It is. In immigration law, lying to an officer or presenting a false intention to gain entry is one of the most severe offenses you can commit.
Worse than just getting turned around and sent home.
Much worse. The penalties for material misrepresentation frequently include permanent, lifetime bans from the United States.
Wow. A lifetime ban.
Yes. So the very first question you must ask yourself at that kitchen table is not, how do I get a visa? The honest first question is, what am I actually coming to the United States to do? Answer that truthfully, and the right visa category reveals itself.
That's powerful. You just have to be radically honest with yourself first. But let's bring it back to the everyday traveler.
Sure.
Let's say you aren't doing any of those heavy things. You aren't getting married, you aren't taking a job in Chicago, you aren't enrolling at NYU. You just need to visit. But maybe you need to stay for 5 months, or maybe you don't qualify for ESTA. For the vast majority of people, there is one visa that stands above all the rest, right? The B1, B2 visitor visa.
Yes. For temporary non-immigrant visits, the B1, B2 is the ultimate tool.
It sounds so technical.
The alphanumeric name sounds intensely bureaucratic, I know, but the fundamental architecture of this visa is actually quite brilliant.
Okay, let's unpack this B1, B2 structure, because from the research, it's basically the Swiss Army knife of immigration.
That's a perfect analogy.
You've got different tools built into one device. The B1 half covers the business side of things, not employment, but business, like attending a conference, taking meetings, negotiating a contract with a vendor, or going to a trade show.
Exactly. You're doing business, but you aren't on the U.S. payroll.
Right. And then the B2 half covers the personal side. You know, taking a holiday to the Grand Canyon, visiting your sister in Chicago, attending a wedding, or seeking specialized medical treatment.
And the genius of the system is that the U.S. government recognized that modern travel often blends these purposes.
Like someone goes to a conference and stays a few extra days for fun.
Precisely. Historically, they issued these separately, but it created immense bureaucratic friction if a business traveler suddenly wanted to take a 2-week vacation. So now, they are almost universally issued together as a single combined visa in your passport.
Oh, that's really smart.
It is. If you apply focusing entirely on a business trip, the tourism side comes right along with it.
That is incredibly practical. It means you don't have to predict your future travel needs for the next decade. Because, well, once a D1, B2 is granted, it's often valid for 10 years, allowing for multiple repeat trips.
Yes, assuming you don't abuse the rules on any of those trips.
Right, of course. Now, to really ground all this theory in reality, the team at the law offices of Chris M. Ingram provided us with 2 composite case studies.
Oh, good. I love these.
Yeah, they're great. These aren't real specific individuals, but they are amalgamations of the exact types of everyday situations our attorneys see every single week. Let's bring them into the conversation so we have some actual human beings to follow through this maze.
A great idea. Bureaucracy only makes sense when we can visualize the real human stakes involved.
Exactly. First, let's meet Elena. Elena is a primary school teacher living in Lisbon, Portugal. She's deeply invested in her job, she's the kind of teacher who knows all her students' quirks.
She sounds lovely.
She is. And her absolute best friend from university, the person who was there for every heartbreak and late-night study session, is getting married in Boston.
Okay, a huge life event.
Huge. She has asked Elena to be a bridesmaid. Now, Elena has never applied for a U.S. visa before. She's never even seen the inside of an embassy. And she is lying awake at night, terrified she's going to mess up the paperwork and miss the most important day of her best friend's life. This is a classic B2 personal visit scenario.
And her anxiety is completely normal. The stakes feel incredibly high to her.
They really do. And then our second traveler is Lucas. Lucas is a custom furniture maker based in England.
Oh, nice.
Yeah, he has spent years painstakingly building up a small independent workshop operating on razor-thin margins. And at a major trade fair in London, a representative from a massive American retail company saw his woodwork and loved it.
That's the dream.
Right. They invited Lucas to fly over to their headquarters in New York for a week of meetings to discuss stocking his furniture nationwide.
Wow. So this is a game changer for him.
Exactly. For Lucas, this is the opportunity of his career. It could literally change his life. And he is quietly terrified of fumbling a bureaucratic form and losing this massive professional milestone.
Understand.
This is a classic B1 business visit scenario. He isn't going to work for the American company. He's taking meetings, negotiating a deal, and then returning to his workshop in England.
Right. So we have two totally different reasons for traveling.
Yeah. Elena is driven by a deeply personal emotional anchor, while Lucas is driven by a massive professional milestone.
We worked with Miguel Gonzalez on our EB-1A petition, and it was an excellent experience from start to finish. His deep expertise and meticulous guidance were instrumental in our case being approved without any RFE, a testament to the high quality and thoroughness of his preparation. Miguel stands out for his timely communication and prompt responses, ensuring we never felt left in the dark during such a critical process. His professional behavior and strategic advice provided us with the clarity and confidence we needed to navigate the complexities of the process. We are incredibly grateful for his support and highly recommend Miguel Gonzalez.
B1, B2, and they are about to share the exact same gauntlet of paperwork.
They are. But before we let Elena and Lucas touch a keyboard, we really have to issue a critical warning.
Yeah.
This is a roadblock that can stop this entire process dead in its tracks, regardless of how innocent your current travel plans are. We need to talk about the stricter climate regarding criminal records.
This is intense. The legal research put a huge emphasis on this.
It is perhaps the most vital caution of our entire deep dive today. We must state this plainly. If you have any kind of criminal record, and I mean any kind, like even a speeding ticket, minor traffic infractions are usually okay. But if it was a misdemeanor or felony, even if it is something from decades ago, even if it was incredibly minor, even if your home country's legal system categorized it merely as a caution or a warning without a formal conviction,
Wow.
you need to pause. You must get proper legal advice before you spend a single penny applying for a visa.
Because it's not just a matter of an officer looking at your file saying no and you trying again next week, right? There is a much deeper legal mechanism at play here called inadmissibility. What does that actually mean in plain English?
Inadmissibility is a massive legal barrier. It's like a brick wall. A simple visa denial usually means you failed to prove you qualify for the visa on that specific day. You can often reapply when your circumstances change.
Right, like if you didn't bring the right bank statement or something.
Exactly. But if a specific criminal offense renders you inadmissible, it means the consular officer literally does not have the legal authority to grant you the visa.
Oh, wow. So they couldn't give it to you even if they wanted to.
Precisely. The law strips them of their discretion. Even if they believe your story, even if they like you, their hands are tied by statute. Inadmissibility can only be overcome with a separate, incredibly complex secondary process called a waiver.
But I want to push back on this because I know exactly what someone listening is thinking right now.
Okay, let's hear it.
Someone is thinking, come on, I got into a minor scuffle outside a pub 25 years ago when I was a dumb university student. It was handled with a warning. You're telling me the U.S. government cares about a decades-old, victimless indiscretion?
It is entirely logical to feel that way. A lot of people feel indignant about it. But relying on common sense rather than the letter of the law is dangerously incorrect in this context.
Right, and I should note here, we're not taking sides on whether this is fair or right. We are just impartially reporting on the legal research as it stands today.
Absolutely. We take no position on whether these policies are overly punitive. Our sole purpose is to convey the reality of the environment so you can protect yourself. And the reality is that the climate has tightened significantly. Officers are increasingly scrutinizing almost any contact with the criminal justice system, even where there was absolutely no formal conviction.
The legal research specifically highlighted driving under the influence DUIs as a prime example of this shifting climate. Why does a traffic-related offense trigger such massive issues?
This is where we have to look at the underlying mechanics of immigration law. 10 or 15 years ago, a single old DUI might not have been an insurmountable hurdle for a visitor visa.
Right.
Today, it draws intense scrutiny because U.S. immigration law ties alcohol-related convictions to health-related grounds of inadmissibility.
Wait, health-related?
Yes. Specifically, they're looking for evidence of a physical or mental disorder. In this case, alcohol abuse, associated with harmful behavior that poses a threat to the property, safety, or welfare of others.
So it's not just about the fact that you broke a traffic law. It's that the law forces them to evaluate if you have a dangerous substance abuse disorder. That changes the whole perspective. So what actually happens if Lucas had a DUI from 8 years ago?
It will likely trigger a mandatory requirement where Lucas has to undergo a specialized medical examination by an embassy-approved panel physician before his visa can even be considered.
He has to go see their doctor.
Yes, and he will have to pay for this exam, which includes psychiatric evaluations and blood tests to prove he is in remission and not a danger. It delays the process by months and adds significant stress.
That sounds exhausting. So, if someone is sitting at their kitchen table thinking, well, it was so long ago, my home country barely has a record of it, and it's practically expunged, I'll just check no on the form and skip the headache. What is the reality of that choice?
The reality is that hiding it is the absolute worst possible move you can make.
I figured.
The global sharing of criminal databases between allied nations is highly advanced and constantly updating. The consular officer very likely already sees a flag on your record before you even walk up to the window.
Oh, so they know before you even speak.
Yes. And if you lie about it on the form, you compound the original minor offense with the much more serious immigration offense of material misrepresentation. You turn a potentially solvable problem into a lifetime ban.
Man, that's brutal. So, honesty is the only way. What is the actual solution then? Like, if Elena had a minor shoplifting caution from when she was 18, what does she do?
First, she must obtain the certified court or police records for the incident. She needs the official, government-issued documents showing exactly what the charge was, the specific statute involved, and exactly how it was legally resolved.
Right, because memory isn't good enough for a legal proceeding.
Never rely on memory. Second, and this is the most valuable step you can take, consult with our attorneys at the law offices of Chris M. Ingram before you start clicking buttons on an application.
Yeah, that seems like a no-brainer.
It is precisely the situation where early professional advice changes the entire outcome. They can determine if the offense actually triggers inadmissibility, and if so, how to prepare a waiver application. Guessing in this scenario can cost you your ability to ever travel to America.
Okay, so assuming our composites, Alina and Lucas, have spotless records, no ancient pub brawls, no DUIs, they are ready to face the first tangible physical hurdle of the process. The famously tricky paperwork dragon known as the DS-160.
The DS-160.
The big boss of paperwork.
It really is. It is the standard online application form used for a wide range of temporary non-immigrant visas, and it lives on the U.S. government's Consular Electronic Application Center website, which is ciax.state.gov.
Now, the government website casually estimates this form takes about 90 minutes to complete. But looking at the exhaustive notes from attorney Chris Ingram's studies, they say you should block out closer to 3 hours, especially if it's your first time.
Usually 3 hours.
Let's not just list the traps. Let's walk through what actually happens to people. Let's put Alina at her laptop. She starts the form, she gets to the third page, and she realizes she needs the exact dates of her last trip to Florida 5 years ago.
Right, which nobody remembers off the top of their head.
Exactly. So she goes to the hall closet, digs through a box of old documents, finds her expired passport, and comes back to the computer 25 minutes later. What happens?
She finds a screen telling her the session has timed out, and every single piece of information she just spent 20 minutes carefully typing is gone. Gone. The DS-160 does not save your progress automatically as you type. And for security reasons, the session times out after roughly 20 minutes of inactivity.
It's maddening. Just hearing about it stresses me out. But the fix for this is right at the very beginning, right?
Yes. As soon as you start a new application, the system generates a unique application ID and asks you to select a security question. You must screenshot that ID or write it down immediately. It is literally your only key back into a saved, partially completed form. And every time you complete a page, you must manually click Save at the bottom.
Okay, so Elena learns her lesson, saves her ID, and moves on to the name section. This seems like it should be the easiest part, but the legal research says it catches Europeans out constantly.
It really does.
Let's say Lucas' full name on his birth certificate is Lucas Johannes Vanderberg.
Yeah.
But he just goes by Lucasberg. All his bank accounts say Lucasberg. He types Lucasberg into the form. Why is this a massive problem?
Because the rule is absolute. Your name must be entered exactly as it appears in the machine-readable zone of your passport.
A machine-readable zone?
Yes, that is the section at the bottom of your passport's photo page with all the chevrons and letters. European names frequently include multiple given names or surnames with particles, things like Van, D, Von. Or they feature accented characters, which the US system might transliterate differently. You cannot enter your name how you usually sign your emails, or the shortened version your friends use.
So if Lucas's passport says Johannes Vanderberg, he must include it.
He must. A mismatch between the DS-160 and the passport will cause the embassy security guards to turn you away at the door before your interview even begins.
Turned away at the door? That's devastating after waiting months for an appointment. It's a bureaucratic matching game. Next, let's talk about dates.
Okay.
The form asks for a lot of dates. Your date of birth, passport issue and expiry dates, and your intended travel dates. And there's a specific formatting quirk that trips people up.
The U.S. form uses a day, month abbreviation, year format.
Which is confusing because usually Americans use month, day, year.
Exactly. It is highly recommended to use the provided drop-down menus to select the month by name rather than trying to type it in. Mixing up an American date format with a European date format is a remarkably common error that can render a form invalid.
Oh man, so use the drop-downs, people.
Definitely. Furthermore, the crucial thing is that your intended travel dates, when you plan to arrive and how long you plan to stay, must make logical sense.
And they have to match your story. If Elena puts down on the form that she's staying for 2 weeks for a wedding, but then at the interview she gets nervous and says she might stay for 2 months to travel around, that inconsistency is a massive red flag.
A huge red flag. The officer is staring at the DS-160 while she speaks.
Okay, what about travel history?
I am still in the process, but so far my experience has been very positive. The firm is genuine, makes no false promises, and is always prompt and honest in communication. Stefania Perez is very helpful in clarifying doubts and leaving no loose ends.
The form asks about previous trips to the U.S. and, critically, any previous visa refusals. You must list every single one truthfully.
Even if it was forever ago. Like a student visa from the 90s.
Even if you were refused a student visa 20 years ago, even if you think the embassy has lost the old paper file, you must disclose it.
Why?
Because the digital records are permanent. Leaving a prior refusal off the DS-160, even by accidental omission, looks exactly like intentional deception to an officer who is staring at a screen that clearly shows the old refusal.
Right, because they already have the answer to the test they're giving you. Here's one that I think makes a lot of people inherently uncomfortable. The DS-160 asks for the social media accounts you have used over the last 5 years. I can imagine Lucas reading that, thinking about his business Instagram, his personal Facebook, and immediately feeling a sense of privacy invasion.
It is a modern addition to the vetting process, and it certainly causes anxiety. But to be completely clear, the government is asking for your public identifiers, your account names, or handles.
The stuff anyone could search for anyway.
Yes, the name that anyone on the internet would see. They are never asking for your passwords.
Thank goodness.
Right. Do not ever put a password into this form. Simply list the handles you use honestly. They are looking for security threats or obvious contradictions to your stated purpose of travel.
Like if Lucas says he's just visiting, but his Instagram bio says moving to New York.
Precisely. That would be a contradiction they would spot immediately.
Then there's the location and the photo. Elena lives in Lisbon, so she has to select the U.S. Embassy in Lisbon as her interview location. But the photo requirement, from reading the research, this seems to be the most common technical failure point.
It is notoriously strict. You must upload a digital photo, and the system runs an automated check on it.
It has to be perfect, doesn't it?
It must meet highly specific requirements regarding pixel size, and the background color must be stark, unshadowed white. You cannot use a photo from 3 years ago, and you certainly cannot use a cropped vacation photo where someone's arm is visible on your shoulder.
So no selfies at the beach?
Absolutely no selfies.
Yeah.
Even things like hair covering a portion of your ear or wearing glasses, which are strictly prohibited, will cause the photo to be rejected.
Wait, you can't wear glasses in the photo?
No glasses at all. The best advice is to go to a professional studio that specifically knows the U.S. visa digital specifications.
Okay, so Elena and Lucas have meticulously filled out every page. They've uploaded perfect photos. They reach the end of the form. Here's where it gets really interesting and honestly a little terrifying.
The final submission.
Right, once you hit that final submit button, the form is locked. You cannot change a single character. It is sealed in digital amber.
That finality is daunting. However, before you execute that final submission, the system provides a comprehensive review stage where you can click through summaries of your earlier pages.
But there is a massive, quirky UI flaw that our legal team highlighted, and this is exactly the kind of technical nonsense that drives people crazy.
Oh, the browser arrows.
Yes. If you are reviewing your form and you realize you spelled your mother's maiden name wrong, your instinct is to use the back arrow on your web browser.
Do not do that.
It breaks everything, right?
It does. Using your browser's back and forward arrows will frequently break the form's script. The page will crash, your corrections will not save, and you may get locked out of your session entirely.
That is brutal.
You absolutely must use the specific navigation buttons, the ones labeled Previous or Next, located at the very bottom of the web page itself to move back and forth during the review stage. Go slowly, use the correct buttons, fix what needs fixing, and only then do you hit Submit.
What if you hit Submit, print your confirmation page, and then you realize you made a catastrophic error, like putting in the wrong passport number?
The remedy for a real error after submission is abandoning that form entirely and starting a brand new DS-160 from scratch.
Start all over again.
Yes. You will get a new barcode, and you will have to use that new barcode for the rest of the process.
Well, at least there's a fix, even if it's annoying. So once it's correctly submitted, you get a confirmation page with a barcode and your photo on it. You print that out, you guard it with your life because you have to physically hand it over at the embassy.
Guard it with your life is accurate.
But here is the part that confuses almost everyone. You finish the form, you've hit submit, but you still don't have an interview date. The DS-160 doesn't actually book the appointment.
Correct. It is a completely bifurcated system. The application form lives on the CEAC website. Booking the appointment and paying the non-refundable government visa fee happens on a completely separate scheduling website.
That is so confusing. So you finish at seac.state.gov, and then you have to go somewhere else entirely, like usetraveldocs.com or whatever specific scheduling portal your local embassy utilizes.
Precisely. The most reliable method is to go to the official website of the U.S. Embassy in your specific country and follow their direct links to the correct scheduling and payment portal for your region.
Okay, that makes sense. Follow their links.
Right. On that second site, you will create a user account, you will input the confirmation barcode number from your completed DS-160, you will pay the visa fee, which is currently around $185, and finally, a calendar will appear where you can select your interview date and time.
And as the research notes, wait times for these appointments can be incredibly long depending on the embassy. In some cities, you might be looking at a 6-month wait.
Sometimes even longer during peak seasons.
So the strategy is to get the DS-160 perfectly correct and submitted, and book that slot as early as humanly possible. So Elena and Lucas have conquered the paperwork dragon. Their forms are locked, their fees are paid, their appointments are booked in Lisbon and London.
The hardest part of the waiting game begins.
Right, the date is creeping closer. Now we have to ask the biggest question of all. What is the consular officer actually looking for on the other side of that bulletproof glass?
Ah, yes.
And this leads us to the most critical legal concept of this entire deep dive.
This is the engine that drives the entire system. It is a specific section of the U.S. Immigration and Nationality Act known as Rule 214B.
Rule 214B.
Yes. If you understand 214B, you understand why the interview feels the way it does, you understand why the officer asks the questions they ask, and you understand exactly what your evidence is meant to accomplish.
I'm going to try to define this based on my reading of Chris Ingram's research, and you tell me if I have this right.
Here.
Rule 214B essentially mandates that every single person applying for a visitor visa is presumed to be an intending immigrant. It means the law legally requires the consular officer to look at Elena and Lucas and assume they are secretly planning to move to the United States permanently until they can prove otherwise.
You have it exactly right.
Seriously, they have to assume you're lying about just visiting.
Legally, yes, and because the burden of proof is entirely on you, you're essentially walking into a courtroom where the verdict is already guilty, and you have 3 minutes to present an overwhelming defense.
Okay, let's unpack this, because the psychological weight of that is immense. It's the exact opposite of how we usually think about fairness in Western legal systems. It's literally saying you are guilty of wanting to move there until proven innocent. Why on earth did Congress write the law this way?
It was written this way to protect U.S. labor markets and infrastructure. The government's nightmare scenario is millions of people arriving as tourists and then disappearing into the economy to work unauthorized jobs and utilize public services without paying into the system.
I mean, I guess I see the logic from a policy standpoint.
Yes. By flipping the burden of proof onto the applicant, the law gives consular officers massive discretionary power to deny anyone who seems like a slight risk, thereby protecting the border. It is not the officer's job to find proof that you want to stay. It is your job to overwhelm their legal presumption with proof that you will leave.
This raises an important question, though. How on earth do you prove a negative? How do you prove to someone that you won't do something in the future?
You do it by demonstrating what the law calls non-immigrant intent. You must prove 3 specific things to the officer's satisfaction.
Okay, what are they?
First, that you have a residence in a foreign country which you have absolutely no intention of abandoning. Second, that you are visiting the U.S. for a temporary, specific, and permitted purpose. And third, that you have the financial means to carry out that purpose and return home.
The research from attorney Chris Ingram makes a really sharp distinction here between dual intent and non-immigrant intent. I think this is where a lot of honest people get tripped up and accidentally ruin their chances.
It is a vital distinction to understand. Some visas in the U.S. system, like certain specialized work visas, the H-1B or L-1, allow for what is called dual intent.
Okay, meaning what?
That means the law legally permits you to hold 2 intentions simultaneously. You are coming to work temporarily, but you are also actively allowed to pursue a permanent green card at the same time.
Okay, so you can have one foot in both camps.
Exactly. The B-1, B-2 visitor visa absolutely does not allow for dual intent. It strictly, uncompromisingly requires non-immigrant intent.
So for a visitor, any hint, any whisper of an intention to stay permanently works entirely against you. If the officer thinks you have even a quiet, sneaky desire to maybe see if you could find a job while you're there, or maybe see if you could meet someone to marry, that kills the visitor visa instantly.
Instantly. It is grounds for outright denial under 214B. And this goes beyond just wanting to immigrate permanently. If you apply for a visitor visa, but the officer deduces from your answers that you are actually planning to undertake unauthorized work, like nannying for a family member, or that you intend to enroll in a semester of university, they will deny it. You must use the visitor visa exclusively for visiting.
If the law forces the officer to think everyone secretly wants to stay, how do our composites, Elena and Lucas, possibly prove they want to go home? What is the actual mechanism for proving you will get back on that airplane?
You prove it with your ties.
Ties, like family ties.
Ties are the physical, financial, and emotional anchors that bind you to your home country. And the beauty here is that you don't have to invent these things. They are the real, existing realities of your life.
So it's not about crafting a masterful legal argument or hiring a speechwriter. It's about bringing the receipts of your own existence.
Exactly. You bring an organized, clear folder of evidence. First, you bring the absolute essentials. Your valid passport, the DS-160 confirmation page with the barcode, your appointment letter, and the fee receipt. Those get you in the door. Then, you bring the proof of your ties.
Let's break down exactly what that looks like for our 2 travelers. What does Lucas bring?
For Lucas, the strongest tie is his livelihood. He brings proof of his business ownership, the commercial lease for his workshop in England, his business bank statement showing regular cash flow, and his tax return showing he has an established, profitable career.
That shows he has too much going on at home to just abandon it.
Right. He also brings the correspondence from the American retailer proving the specific temporary business purpose of his trip, outlining exactly when the meetings are and what they are about.
And for Elena, her ties are different because she doesn't own a business.
Elena's ties are institutional and personal. She brings a formal letter from her school's administration in Lisbon.
What should that letter say?
This letter should be on official letterhead, confirming her permanent employment, stating her salary, and explicitly noting the exact date she is expected back in the classroom for the new term. She brings her apartment lease, showing she has a physical home to return to. She brings the wedding invitation from her best friend in Boston.
Basically proving her story is true.
Exactly. Both of them should also bring personal bank statements, proving they have the funds to support themselves during the trip, so the officer knows they won't be tempted to seek unauthorized work to survive.
It's basically a dossier of a life that is simply too established, too secure, to abandon for a risky life undocumented in the U.S. And you organize it neatly so you aren't frantically digging through a backpack while the officer waits.
Yes, presentation matters.
With all that evidence gathered and the heavy legal hurdle of 214B understood, the time for theory is over. It is time for Elena and Lucas and our listener to actually walk up to the embassy doors. Let's talk about walking into the day and dismantling the fear.
The physical reality of the embassy day is often built up into something resembling a cinematic interrogation in a dark room.
Right, like a spy movie.
Exactly. But the truth is far more bureaucratic, mundane, and routine. It is mostly a test of patience.
Let's walk through the sensory experience so there are absolutely no surprises. First of all, the research notes you should arrive about 30 minutes early, not 3 hours early, because security won't let you congregate on the sidewalk, but definitely not late, because being late can literally cost you the appointment slot you waited 6 months for.
Right, 30 minutes is the sweet spot.
What about dress code? Does Elena need to wear a ball gown? Does Lucas need a tuxedo?
There is no formal mandated dress code posted on the wall. However, human psychology plays a role here. You want to visually signal respect for the process, the institution, and the gravity of the request you are making.
So dress to impress, but reasonably.
The legal team's advice is to aim for business attire dress, as you would for a very important professional meeting or a job interview. It should be neat, clean, and considered. It costs nothing to put on a nice blazer or a professional dress, but it quietly communicates to the officer that you take the occasion seriously.
And there is a massive rule regarding electronics that trips people up right at the front gate. You cannot bring your phone, your laptop, your smartwatch, your wireless earbuds, or even a large backpack into the embassy. And most consulates do not have storage lockers outside anymore.
This catches many people off guard. You must leave your electronics at your hotel, locked in your car, or with a friend waiting at a coffee shop down the street.
It's crazy going anywhere without a phone these days.
It is, but it's a strict security rule. Only the applicant is allowed inside. No friends or family unless they are applying to. You go through rigorous airport-style security, metal detectors, x-rays. Once inside, you will have your fingerprints digitally scanned at an initial window. And then you wait.
You wait. And wait. You might be sitting in a sterile room with hard plastic chairs, surrounded by hundreds of other nervous people, for 2 or 3 hours just waiting for a digital display board to flash your ticket number.
And if you look around that room, you will see every conceivable type of person. Students, grandparents, business executives, musicians, all doing the exact same thing. And the vast majority of them are going to be perfectly fine.
Eventually, your number chimes on the board and you walk up to a counter. You are standing looking through a thick pane of bulletproof glass at a consular officer sitting at a computer terminal. They are typing, looking at your DS-160. This is the fabled interview. And from everything we've read in our team's research, it is incredibly brief. We are talking maybe a 3-minute window. Why is it so fast?
It is entirely due to the volume of applicants. These officers conduct hundreds of interviews a day. They have incredibly limited time to make a legal determination. And this highly compressed time frame brings us to the core fear we need to dismantle.
Yeah, let's talk about the fear.
People stand at that window terrified, thinking, what if I tell the complete truth but my voice shakes or my hands sweat and they think I'm lying?
Which is such a deeply human fear. When the stakes are high, our bodies betray us, we sweat, we stutter, we lose our train of thought.
Exactly. But the consular officer is not a human lie detector hunting for a micro-expression of deception. They conduct these interviews all day, every day, for years. They know people are nervous. A shaky voice, a sweaty palm that does not automatically read as dishonesty to them.
Oh, that's a huge relief. So what are they actually doing then?
They are looking at the macro picture, not the micro jitters. They are quietly weighing one overarching question. Does this person's story hold together? Does this individual's life and their stated reason for travel add up logically to someone who will visit temporarily and then go home?
So what does this all mean for how you actually speak to them?
It means you absolutely should not rehearse or memorize a rigid speech. Rehearsed answers sound like a script, and scripts sound deceptive. When a script gets derailed by an unexpected question, the applicant freezes. You want to sound like a real human being describing their actual authentic life.
The art of answering, as the research beautifully puts it, is to answer warmly and completely. The officer is going to ask straightforward questions. Why are you traveling? How long are you staying? What is your job back home? Who is paying for this trip? The worst thing you can do is give clipped, one-word defensive answers.
Absolutely.
Let's role play this for a second. If the officer asks Elena why she is traveling, and she just stares blankly, grips the counter and mutters, "A wedding," what happens?
That gives the officer absolutely nothing to work with. It forces the officer to drag the story out of her question by question, which builds tension and slows down the interview. It makes her seem evasive, even if she is just terrified.
Instead, she should answer completely. Like, my absolute best friend from university is getting married in Boston. I'm going over for 2 weeks to be a bridesmaid, and then I'm flying right back to Lisbon because the new school term starts and my primary school kids will be waiting for me.
That is exactly how to do it. It is warm, it is factual, and without explicitly arguing the law, it perfectly answers the underlying question of Rule 214B.
Because it proves intent.
Exactly. She established a specific temporary purpose, a wedding, and a compelling tie-her teaching job that pulls her back home. Lucas does the exact same thing. I'm a custom furniture maker. I'm heading to New York for 5 days of meetings with a retailer who wants to stock my pieces, and then I'm straight back to my workshop in England to fulfill my current orders.
Because they aren't performing a play, they can't be caught out in a lie. Because their ties are genuine, they are just describing reality. And after those 3 minutes of conversation, one of 3 things is going to happen. Let's outline the outcomes so the listener is prepared for the end of the line. Outcome number 1, the clean he's yes.
This is what happens in the majority of well-prepared cases. The officer says you are approved. They will keep your passport right there at the window. You leave the embassy empty-handed, and a few days later, your passport is returned to you via courier with the U.S. visa securely glued into one of the pages.
Best feeling ever. Outcome number 2, the refusal letter.
The officer hands your passport back to you immediately, right under the glass, along with a standardized letter, often referring back to that 214B rule we discussed, stating that you did not overcome the presumption of immigrant intent, and the visa is denied.
Which is heart-wrenching, but at least you know. And outcome number 3, which sounds incredibly confusing, the colored slip.
Yes. The officer might hand your passport back, or they might keep it, but they hand you a colored piece of paper, often green, yellow, or pink, which indicates your case requires administrative processing under Section 221G of the Immigration and Nationality Act.
Which is terrifying because it's not a yes and it's not a no. It's a bureaucratic limbo state. What does it actually mean?
It is a pause. It usually means the officer needs more time to verify something. Perhaps a security background check needs to run its course in Washington because your name matches someone on a watch list.
Well, that makes sense.
Or perhaps they need you to email them one specific missing document, like an updated tax return or a more detailed itinerary. It is crucial to understand that a 221G slip is very often just a pause, not a true refusal, provided you follow the instructions on the slip perfectly and supply the requested information.
So we've taken Elena and Lucas, and you listening right now, all the way from the kitchen table at midnight to the final moment at the window. And I think the goal here is that when you stand at that window, you aren't vibrating with that brittle, fragile confidence of someone who memorized a script.
Right, you want to be grounded.
You are standing there with the quiet, durable, unshakable confidence of someone who simply has a true story to tell.
That is the ideal state to be in. The process is undeniably more thorough than it used to be. The scrutiny on criminal records is higher. The forms are less forgiving of technical errors. But that thoroughness ultimately rewards the applicant who is honest, organized, and prepared.
It's fascinating to me, honestly. We live in this era of high-tech digital vetting, of algorithmic risk assessments, of massive global databases sharing our data in milliseconds. But at the very end of all of it, the ultimate key to unlocking the border of one of the most powerful nations on Earth often comes down to the simple, deeply human act of looking someone in the eye and telling the truth about your own ordinary life. It's a remarkably human bottleneck in a digital world.
It is a profound reality. The system, for all its technical complexity, ultimately relies on human judgment evaluating human truth.
So let us leave you with the heart of it. The visa interview people dread is usually over in just a few minutes, and the secret is that there are no perfect words to find, only your own true story to tell, warmly and completely. Choose the right visa for your real purpose. If you have any kind of record, talk to us before you apply. Complete that demanding form slowly and honestly, and remember you cannot change it once it is submitted. Bring the simple proof of your real life and spend your real energy on the one thing that matters most. Knowing that your ties to home, your job, your family, your whole life are already true. The process is more thorough than it used to be, but thoroughness rewards the honest and the prepared. If the answer turns out to be anything other than a clean yes, do not panic and do not guess. Listen to our companion episode on what a refusal really means and what your options are. The strategies in this discussion are for educational purposes only. Your situation is unique, and the law offices of Chris M. Ingram are here to help you understand your specific options. If you would like a clear, friendly assessment before your interview, visit breakthroughhunasa.com and reach out for a free consultation.